Have said some of them can represent
No, that was 1884 Pramod Verma. That has changed now. You see the judgment of Justice Deepak Mishra in Ranjan Kumar. They have considered Pramod Verma and said that now everyone has to be Pramod.
and they were well.
Madam, Ranjan Kumar, that means Ranjan Kumar versus Deepak Mishra.
And also, I know your Lordship doesn't really agree with that view. There are at least 6 or 7 judgments of the Honorable Court where your Lordships have said that if what is an issue is an interpretation of a rule, then the rulemaking authority, whether the union of the state is the requisite party, and those being affected are not required. That's also a view. But another time where your Lordship has some reservation on that.
If it has the effect of not dislodging them from their service.
But Malas, here, today we are all before your Lordship. Your Lordship, I have to see, Malas, whether we are covered by your Lordship judgments and whether, Malas, the merit list. What is key is that the merit list, Malas, gives no concession to us. In the preparation of the merit list, we have not got a single mark at all.
Just 1 minute, let us refresh our memory.
Of course.
सभी लाइव को शेयर करें, ज्यादा से ज्यादा चैनल को सब्सक्राइब करें, लाइक जरूर करें और कमेंट करके बताएं कि आपको क्या लग रहा है, फैसला किस साइड हो सकता है। लाइव को शेयर करें यार, बहुत कम लोग शेयर ही नहीं कर रहे। आप सभी लाइव लोगों के पास पहुंच नहीं रहा। उत्तर प्रदेश में कितने लाखों लोग इसको वेट कर रहे हैं कि लाइव का डायरेक्ट प्रोसीडिंग देख सके, आप सभी शेयर नहीं कर रहे हैं। लाइक जरूर कर दीजिए, लाइक का कोई पैसा नहीं लग रहा है। सभी जगह दोस्तों के पास, सभी जगह ग्रुप में शेयर करो लाइक को। मात्र 1800 लोग लाइव देख रहे हैं। 6800 की तो
फाइल में भी इम्पोर्टेंट।
यूपीएससी की तैयारी करने के लिए बहुत जरूरी है कि आपको अपना फाउंडेशन स्ट्रॉन्ग बनाना होगा एंड इसके लिए एनसीईआरटी से अच्छा सोर्स कोई हो ही नहीं सकता है।
The case at hand, neither it was any rule nor any regulation challenge. In fact, we have been apprised at the selection and appointment, there was no rule or regulation, unlike the present case.
So 5 may not apply. Come to 7.
Mishra
The court took note of the fact that when no steps had been taken in terms of Order 1, Rule 8, or the principles analogous thereto, all the 17 selected candidates were necessary parties. It was further observed that the number of selected candidates was not many and there was no difficulty. Ultimately, court held that when all the selected candidates were not impeded, no relief could be granted. So therefore, you see, after Pramod Verma, there has been a long line of decisions. And come to para 13, that is the law declared in this matter. In such a case, when all the appointees were not impeded, the writ petition was defective and hence no relief could have been granted.
May be remanded by the order of publication, and this refers to the rules of the court. Perhaps similar to magistrate, there is one copy produced order so on. So
by the said order dated so and so, the opposite parties number so and so and so and so were directed to issue a circular and to publish in daily newspapers intimating those candidates who have been selected against the vacancies reserved in OBC, SC and other categories who may have concern to defend themselves as per provisions contained in Chapter 23, Rule 5A of the Rules of the Court within a period of 2 weeks. Rule mentioned therein is not applicable and the counsel for the petitioner admits to the error. He, however, says that the only substantive objection raised by the opposite party is that it is the petitioner who approached the court, therefore they should get the publication of notices made instead of the state, which the petitioners are ready to do. On this, she also says that with clarification, the application can be disposed of. In view of the aforesaid, it is provided that publication of notices in newspapers as directed with the order so-and-so shall be gotten by the petitioners as per rules of this court and the practice followed therein, and not by the opposite party number so-and-so, so-and-so. Application stands disposed of accordingly. All impediment applications to be filed by selected candidates in any of the select list, in any of the repetition, which are part of the bench stand allowed, a right of hearing to the said appellants. The names of their counsel should be shown in the cause list whenever the cases are listed. Counsel for the parties agree that, broadly speaking, there are 4 categories of cases. First is the category where the select list of selection for 69,000 teachers, as originally published, has been challenged on the ground that those reserved category candidates who have secured the requisite merit entitling them to be placed in the unreserved select list have not been so placed. Second category is so-and-so, etc. Opposite parties in the petition shall file a response within 3 weeks. We get out. So, as per the rules of the court, the publication was directed to the writ petitioners, which was done, and there were several impediments which were all allowed.
No, this was concerning the 6,800 reserved people who were subsequently selected. Considering that only, there was a prayer as per, there was a separate petition law. 6,800 people were selected from the reserved category because the state thought they were not adequately represented. That was separately challenged in another petition which is decided in the common judgment. That also. The notice was mentioning that. That's what, please, paragraph 50 is what we have to see. Not for that, only for this 28.
The implications from both sides.
They challenged the ATR. They challenged the ATR. We are all there, whether you're in my spirit or
Not taken up the points of the migration from the unreserved category, general category is permissible under the 6 have been considered. The level series just may not that it cannot be. The HR cannot be
not there as a
Please see paragraph. No, paragraph.
for that reason and for other
Paragraph.
subject. This is not an objection.
Paragraph.
Not an objection raised. Yes, and one subject to correction.
Shivam matter that was
Incoming call from my control room. Red heart identified by Tricaller.
Hear you again on Monday nights. He wanted to tell you that. So that order is recalled. And so next one.
the citation of the salary. You're not supposed to do that. Not a case which category was under this. So the reservation will not persons who had applied under the reserved category, but will not later on the basis of the marks which they had obtained, they were permitted to migrate. And on the basis of the migration, after the migration, once the migration was accepted, when they were appointed, it could be appointed dates will not have the vacancies, which always were in the way that was permissible because when the question of reservation date comes up, if a reserve category that obtains marks, placing it above the person who has obtained the least number of marks for general category, then he is entitled to be appointed against the unreserved or the general category. But this is on the basis of the law that has been considered by the Honorable Court. What the learned single judge held
that it is not permissible to do so because ATR comes with the, if they are already using the medical reservation in becoming eligible, then they are not eligible to buy. This is what was division bench. Considering that there are categories of hope issues which are to be considered. But when it already said, somebody who has already taken a stand was underrepresented or was not done by the division. That your lordship will come across in my knowledge of submission. Then your lordship will. Yes.
Which is why they don't object to this in the SLP, is my instruction. They not raised this ground that we were not allowed to the SLP, at least in that one matter.
He raised. We have raised.
Yes.
Because I have shown the two statutes which are governing. Now, my lords, the entire confusion is a reason because of the TET being confused with ATR. My lords, the TET qualification is eligibility is very different from my lords competing and qualifying according to the open competitive examination. That is how they want to equate it, and that is why the legal benches are. Now, my lords, I will tell how my lords qualifying marks of a competitive examination is different from eligibility. My lords, kindly see the history of the my lords, volume 1 of this part. My lords, we have annexed that earlier the state of UP, my lords, I may not go. The state of UP had said even ATR is eligibility. Then it was challenged. It was felt that eligibility can only be determined by the central government or that its body because it's a domain of the central government. So therefore, the state government amended its rule and brought ATR as a qualified.
You are perhaps not quite right on that because as per the definition in the rules, it is a test to be conducted by the government or the government of India. Government means government of Uttar Pradesh.
Yes, ma'am, that is fine. But ma'am, maybe I stand corrected. All that we are saying is it was brought out of the eligibility criteria and brought as a part of the open competitive examination is what I said. And I pointed out the rule also. That's why that is how Manoj had paid.
But are they right in saying that this point has been settled by this court?
No, man.
I've seen that.
Manoj, maybe, Manoj, I work with that, but no. According to us, no.
So you have
According to us.
reference with you?
Yes, Manoj, I'll go to each of that reason. According to us, no.
When they are raising this point that this is settled, why don't you persuade us to hold that it is not so settled?
I directly come to those judgments. Yes, yes.
No, he knows. No, he said
According to us, Manoj, I'll point out the differentiation.
judgment and say that this is the reason why we should not be guided by this judgment.
Manoj, may turn to 2017 one SC.
सभी लाइव को शेयर करें ज्यादा से ज्यादा लाइक जरूर करें
This is the sheet anchor. Then I will directly take to the offending. Well, this is their sheet anchor, as far as I know. Vikas Sankla. My lord, I may stand corrected, but according to me, my lord, this is the judgment which is nearest to them. Maybe some other judgment, but this is according to us, this is the nearest to their, my lord, which they can rely on. In this matter, what had happened was, before going through, that was an issue. And the court said that you have a level playing field, you create a level playing field. The eligibility relaxation in TED would not constitute any kind of, my lord, benefit to be considered under the general category. No, but there is one more catch. They might rely. What had happened was, I think that marks were also used for the purpose of computation of merit. To which they said that it will be neutral to negative to the reserve category because if they anyway they have got the relaxation, so the TET marks are less. So even if you include in the merit category, they will be at the bottom of the list, and therefore it is not going to impact the reserve category, general category. Some of that reasoning I must point out is at page 80. 80 and 81, what they have said is that even if you have that examination, they would be at the bottom, so it will not impact the general category. Having regard to the respective submissions, also got it, para 81. First aspect that needs reconsideration is whether relaxation in TET marks could amount to concession in the recruitment process. The High Court has had that to be on the premise that para 918 dealing with such elections in 10 marks forms part of the document relates to recruitment procedure. It is difficult to accept this rationale or analogy. Passing of TET examination is a condition of eligibility for appointment of a teacher. If it is necessary qualification without which a candidate is not eligible to be considered for appointment. This was clearly mentioned in guidelines of notification dated 1/2/2011. These guidelines pertain to conducting of TET, basic features whereof have already been pointed about. Even para 9, which provides for concession that can given to certain result category, deals with qualifying marks that is to be obtained in TET examination. Thus, a person who passes TET examination becomes eligible to participate in the selection process as and when such selection process of filling up a post of primary is taken by the state. That is not part of the selection process. On the other hand, when it comes to recruitment of teachers, the method of recruitment of teachers is altogether different. Here, merit list of section is to be prepared on the basis of marks obtained on different heads. One of the heads is marks in TET. So far as the head, 20% of marks in TET are to be assigned to each candidate. Therefore, the reserve category candidates who secure lesser marks in TET would naturally get less marks under this head. We would like to demonstrate it with an example. Suppose the reserve category obtains 53 marks in TET, he is treated as having qualified TET. However, when he is considered for selection to the post of primary teacher in respect of allocation marks, he will get 20% marks for TET. As against him, a general category secures 70 marks, TET shall be awarded 40 marks in the recruitment process. Thus, on the basis of TET marks, reserve category candidate has not got any advantage while considering his candidature for the post. On the contrary, level playing field is maintained, whereby a person securing higher marks TET, whether belong to reserve category or reserve category, is allocated higher marks in respect of 20% of TET marks. Thus, in recruitment, no weightage or concession is given, and allocation of 20% TET marks is applied across the board. Therefore, the High Court is not correct in the concession was given in 20%. Here, the concession is given. A person is reduced from 65% to 60%. Then 81. Once the vital differentiation is understood, it would lead to a conclusion that no concession becomes available to the reserve category candidate by giving relaxation marks in TET. Insofar as recruitment process is concerned, it only enables them to compete with others by allowing them to participate in the selection process. In this backdrop, irrespective of circular, the reserve category candidates who secured more marks in the last candidate select category would be entitled to be considered against unreserved vacancy. However, it would be subject to condition that they have not availed any other terms of attempts except on fee and age. Here they have said on attempts. So, my lord, this is the judgment which is according to us. Here the TET was applied across the board. In our case, the concession has been given for the next 60% of the weightage has been concession has been given to them. Advantage has been taken by them. Therefore, it becomes a distinguishing feature.
Yes.
And my lords, as far as my lords, this judgment, honorable, there is one judgment, my lords, which my lords, according to us, my lord, they have one case distinguishes this judgment, 2910 SCC 120.
सभी शेयर करें, लाइक करें, लाइव को लाइक जरूर करें, प्लीज लाइक करें, सभी जगह शेयर करें, चैनल को सब्सक्राइब नहीं किया तो सब्सक्राइब जरूर करें.
This was judgment of Vikas Sakla, 2019 and SCC 120.
शेयर करें, प्लीज शेयर करें.
For convenience, all the judgments being relied upon are together in one compilation. Just to take out this current court master. all these judgments that are being relied upon and the compilation. We've
Just ask him not to take out. Krishna, just ask him not to take out these judgments.
he copies the same pattern. We have fact volume and all the judgments are there. The index has the judgment para numbers and the citations.
Incoming call from Pramod Jijimi Zagara identified by Truecaller.